Hi, I'm Barry Smith. I go by Legal Bear on the internet. Sometime around 1990, I heard the creator speak to me. He said, get a computer, learn how to use it, and start studying law full time. One of the ways I learned law was taking all my traffic tickets to trial, and if I lost, by appealing them. Somebody once said it's like performing surgery on yourself. So now I'm being prosecuted. I'm working the counsel list, so I tell the judge, I'd like counsel on this case, but I don't want to waive my right not to incriminate myself to get it. I tell the judge, the Supreme Court has said that they find it intolerable that one right should have to be waived in order to assert another. The judge replies, I see. So you're refusing to fill out the financial affidavit because then the entire government might have your financial information, even though that information is protected in the court file. And of course, the public defender's office has to keep it confidential because if they are appointed, they have an attorney-client relationship with you, which is confidential. What the judge didn't know is that I've been watching the public defender hand the defendant's financial affidavits to the prosecutor on other cases. What else the judge didn't know is that I had read the public defender statute itself and saw in that the financial information was shared with the prosecutor. So this judge is revealing his character and his integrity, and what he is revealing is not good. The judge also said, Mr. Smith, this isn't a novel idea that you've come up with. The court is aware of these arguments, and it does not apply in this case. Why, yes, Judge, and I can see that you're well qualified to counsel me on this issue. The judge continued, I won't do it this morning because I had this set for your appearance and for the filling out of your affidavit. The judge also said, no, the law doesn't. The law doesn't give you. First of all, we start with the Constitution, and you can cite all the cases you want, but we start with the Constitution. Well, duh. Cases I'm citing are discussing the Constitution. You know what? He should have known that too. To me, his references to the Constitution were just meaningless lip service. But after saying that, the judge went right back to the statute saying, it's the law that says you're entitled to get an attorney appointed after 5 big words, letters in one word, after you fill out a financial affidavit that's prepared by the state. It's required of all defendants who want court-appointed counsel. The 5-letter word must have referred to the word apply, but he just never got around to saying it. So I asked for assistance from the public defender in filling out the application, to which the judge replied, there's no right for me or any authority or no right on your behalf under any case law to have the court order Mr. Townsend to advise you on whether or not you should fill out the affidavit or how you should fill it out or all those other things. His job starts after you complete it. Then he has a duty to bring it to me, which he does, and I have a duty to review it and if you qualify to appoint. I later read the Chief Justice's directive on appointment of counsel, and I learned that this was also a lie. So let me see. If I've got this straight. You want to appoint me counsel to help me fill out a sworn affidavit that could incriminate. Here's what the judge knows. If I get counsel to help me fill out the sworn affidavit regarding every financial detail of my life, and the counsel hears that I have issues with the IRS, what's he going to tell me to do? He will tell me not to fill it out. Any attorney with the salt tells you, as soon as you might provide a link in a chain, don't speak. A leak in a chain that might lead to your prosecution, don't speak. There's another option that I would not agree to request, something called an in-camera review. Why wouldn't I agree? I don't trust the judge. I've already figured out the IRS played a role in my being prosecuted by the state. I read a Supreme Court decision noting that once information about you is out there, it'd be impossible to get it back. I mentioned to the judge a Colorado appellate case where the court said, consequently, since the determination of indigency is subject to judicial review, information given the public defender in this regard cannot be considered confidential. To which the judge replied, the People v. Lambert does not apply to the situation I'm talking about. You're not going to receive any further assurances from the court or court orders because Colorado state law and cases that are holding make it quite clear, number 1, there is income guidelines, and number 2, the court cannot appoint the office of the public defender until such time as it has an application from them either recommending appointment or telling me that you are not eligible. Having read the Chief Justice directive on appointment of counsel, I knew that this was also a lie. So pulled out the memorandum I wrote to the Idaho court about how the Fourth and Fifth Amendments collided to protect us in the production of our papers that might result in a penalty or forfeiture of property. I filled out the application. On every line I thought could incriminate me, I put C memorandum. I called it Memorandum to Support Application for Public Defender. And that's what this video is about, what went into that memorandum. As I'm noting the quotes from the memorandum, if you see this symbol, the seal of the Supreme Court of the United States, I'm quoting from the United States Supreme Court. And if you see this symbol, I'm quoting from a Colorado appellate court. So I go through this memorandum of what I said. So I pointed out, the court attempts to extort for the parties private books or papers to make them liable for a penalty or to forfeit his property. I don't know that I'm necessarily liable for a penalty, but they're extorting from me my private books and papers to apply for my right to state-paid counsel. I said, but claims of overriding interest are not unusual in Fifth Amendment litigation, and they have not fared well. The point being, he's trying to tell me that the state has an overriding interest in my financial information to decide whether or not I'm entitled to state-paid counsel. And what is shown here is that the Fifth Amendment tramples on his statute, where the legislatures didn't give me any consideration as to my right. The court continued, we've been able to perceive that the seizure of a man's private books and papers to be used in evidence against him is substantially different from compelling him to be a witness against himself. So they're asking me to witness against myself on this state public defender application. A confession must not be extracted by any sort of threats or violence, however slight. Well, threatening to not give me state-paid counsel, that's a threat. A person must not have been compelled to incriminate himself. But it accomplishes the substantial object of those acts in forcing from a party evidence against himself. It is very certain that the law obliges no man to accuse himself, because of the necessary means of compelling self-accusation, falling upon the innocent as well as the guilty, would be both cruel and unjust. But the Constitution is filled with provisions that grant Congress and states specific power to legislate in certain areas. These granted powers are always subject to the limitation that they may not be exercised in a way that violates other specific provisions of the Constitution. So here we've got, yes, you had the right to legislate the state-paid counsel, but you did not have the ability to force us to waive our Fifth Amendment right in order to obtain that. The principles laid down in this opinion are the very essence of constitutional liberty and security. Courts need to take a class on constitutional liberty and security. It's the invasion of his indefeasible right of personal security, personal liberty, and private property. Any compulsory discovery by extorting the party's oath, that's what it was. Public defender application, at the bottom it says, I swear under penalty of perjury that this is true, or compelling the production of his private books and papers to get victim of a crime or to forfeit his property is contrary to the principles of a free government. The 14th Amendment secures against the state invasion the same privilege that the Fifth Amendment guarantees against federal infringement. The right of a person to remain silent unless he chooses to speak in unfettered exercise of his own will and to suffer no penalty. In this case, no penalty would be being denied state-paid counsel for such silence. No penalty for the silence. But for no penalty, you suppose that includes not being denied state-paid assistance of counsel? What is accorded is the privilege of refusing to incriminate oneself, and the feared prosecution may be by either federal or state authorities. Of course, the memorandum cites the exact Supreme Court decision that says that. It must be considered irrelevant that a petitioner was a witness in a statutory inquiry. What's an application for public defender in Colorado? It's statutory. Later, I'll show you the exact statute. The memorandum pointed out, and People v. Lambert, Ms. Lambert contended that the prosecuting attorney's use of this information, which was in the public defender application, in cross-examination, violated the defendant's Fifth Amendment privilege against self-incrimination. The memorandum pointed out, the court did not agree, saying, when Mrs. Lambert waived her right not to testify at her trial, her credibility is thereby placed in issue to the same extent as would be any other witness. Evidence of her prior inconsistent statement, since it, that being it was the public defender application, was not protected by any claim of privilege and was therefore admissible against her. You realize that's what that's saying? That's saying I'm right and the judge in my case was wrong. But wait, my trial judge just got done telling me the application was subject to attorney-client privilege. Question: where did the prosecutor get the application to use in cross-examination? The memorandum pointed out in the case of People v. Schuper, the court recounted that initially the Office of the Public Defender was appointed to represent Schuper based on his application. The memorandum pointed out, but after the people contested the appointment, the trial court determined that Schuper had considerable assets and bank accounts and revoked the appointment. The memorandum pointed out the people then brought charges against Schuper for first-degree perjury, violation of bail bond conditions, attempt to influence a public servant, and offering a false instrument for recording based on his application for court-appointed counsel. The memorandum then went back to quoting U.S. Supreme Court. The very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy and to place them beyond the reach of majorities and officials and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, free press, freedom of worship, assembly, and other fundamental rights, such as state-paid counsel, may not be submitted to vote. They depend upon the outcome of no elections. The memorandum pointed out, it looks to me like Colorado legislators put my right to be secure in my papers and my right not to incriminate myself to a vote when they voted to enact 211-1033 CRS, which is the Public Defender Application Statute. They voted that they could take away my rights to make it easier to protect the public fisc at the expense of my rights. The memorandum then went back to quoting the U.S. Supreme Court. There's no mysticism in the American concept of the state or nature and origin of its authority. We set up government by consent of the governed. Recognize that from the Declaration of Independence. And the Bill of Rights denies those in power any legal opportunity to coerce that consent. Looks to me like that judge was doing his best to coerce my consent. No legal opportunity. That must mean that this judge's attempt to coerce my consent were all illegal. The memorandum pointed out, it looks to me like at 211-103 CRS, application is designed to coerce my consent contrary to the Bill of Rights. The memorandum concluded by saying, so the government, again, by putting my rights to a vote, has decided by way of 21103 that I have no rights when I seek court-appointed counsel at state expense. To order this memorandum and two others like it, dealing with asserting your right to be free from involuntary servitude, your right not to identify yourself, look for the links in the description of this video.